All right, now we're talking about the people that run the corporation. And these are directors and officers. And really, the ones that truly run the corporation are the directors, and they tell the officers what to do. All right, read the chapter objectives as usual on your own. And even though I said the directors really run the corporation, the ones actually doing the day-to-day operations are those officers. And there are requirements sometimes for being a director. Sometimes the corporation has decided that they want people to be a certain age. Maybe the corporation wants people to live in this state where the corporation is incorporated. And the directors are elected by the shareholders. So if you ever have owned any stock, sometimes you'll get in the mail something that you might have ignored. Most people do. And that is, election of directors for that corporation. If they don't get enough ballots, then they have to rerun that election, and that can cut into profit. So it's always a good idea to go ahead and vote for those directors. Now, directors can be removed without cause, and like we were talking about, the officers are different, and they're appointed by the directors, and they can be removed by the directors. All right. So we may need shareholder approval for some of the actions of the directors, such as amending articles or bylaws, issuing stock, that sort of thing. Directors are the ones that declare the dividends, and they have to manage the officers. And officers do things more to like day-to-day operations, keeping the minutes, keeping the records. And officers have titles such as president, vice president, secretary, and treasurer. Now, election and appointment. So you can have a one-person board of directors. The number of directors will be put in the bylaws. There needs to be some way to break a tie if there's an equal number of directors. And directors can have what's known as cumulative voting. So the number of shareholders is the number of shares, actually, is multiplied by the number of open positions. So, for example, if there's 540 shares and then 2 open positions, then 540 times 2 would be 1,080 votes. There can also be elections of directors with straight voting, which is 1 share equals 1 vote. All right, now the organizational meeting that we talked about a couple chapters ago is when incorporators typically appoint the first directors, and then after that, then they're voted for at the shareholder meetings. Term is usually 1 year for directors, and officers can be removed at any time because they're appointed by those directors who can hire and fire them. Vacancies, there's usually an appointment for directors until the next election cycle because it's expensive to have a special election. Sometimes people will do it anyway, or corporations will do it anyway, but it can be expensive. Now, because officers are appointed, then their vacancies can be just replaced by a director that appoints a new officer. All right, board of director meetings, they have to have an annual meeting. They ratify the past year's actions taken by officers. They appoint officers. They might issue dividends. They look at the financials, and they have to do annual reports. Now, they can have more than 1 meeting a year. The notice requirements for a board of directors meeting is much less than for a shareholders meeting. There must be a quorum, and that quorum could be anywhere from 1/3 to 51%, depending upon the bylaws. And they need to have a quorum of directors at each of the board of directors meetings. Now, board of directors don't always have to meet in person. They can meet like Skype or phone, but it's not as common to do it that way as well. It's becoming more common than in person. It's not very common anymore to have a written meeting. And board of directors strike that. All right, duties. Board of directors on the board of directors have extra special duties because they're in this position of power. They're, in charge of our money being invested. So they have like a monetary duty or fiduciary duty. They have a duty of care, which is an ordinary person or ordinary director's standard to act with care toward the shareholders. They have to be loyal to the corporation. We have to look at good faith. Did they come to meetings? Did they know what they were talking about? Did they participate? Did they embezzle? And this duty of loyalty applies to both directors and officers. All right, directors and officers have to be to the corporation and the shareholders. If the shareholders, well, not shareholders, but the corporation's interest above their own. They can't have a conflict of interest. Insider trading would be a conflict of interest. They can't take the corporate opportunity for themselves. So if you're paying attention to Guth versus Loth in the book, that's the case you need to know. Mr. Goth basically took a Pepsi opportunity for himself and didn't offer it to the corporation first, which he was required to do. Compensation is going to be in the articles or the bylaws, but if it's not, then the board of directors can set it themselves, and it can include stock. Now, part of the problem we've had in the past is that directors typically have to be indemnified before they will be willing to serve as board of directors. So what does that mean? That means the corporation agrees to pay lawsuits on its behalf on their behalf if the director is sued. So if the person is honest and trustworthy, this is fine. But if they're not, then the corporation has basically agreed, in some cases, to go ahead and pay lawsuits that are legitimate against them. So that can be a problem and encourage some nefarious people to act in ways that they shouldn't be acting. Officer compensation is determined by the directors. All right. If the director is not indemnified or the officer is not indemnified, then they can be sued and often be held responsible for their actions. And the court will look at whether, under the business judgment rule, whether the director or officer made a decision in good faith. And then if he did or she did, then they can't be held personally liable. Another big argument that directors and officers make when they're sued is that they were relying on someone else, like, for example, the corporate attorney or the corporate CPAs. And the corporation can also take out insurance on behalf of the directors and officers as well. So if they are sued, the insurance company might pay for that lawsuit depending on the result and what the person was sued for. So what do they have to do, directors and officers? They have to act without conflict of interest. They have to act as a reasonable director or officer, and they have to act in the best interest of the corporation. Okay, we already talked about that slide.